Executive Associate Dean of my law school. And so I feel I have much in common. I feel a great affinity with chief compliance officers, since that's often the role that I seem to be playing between ABA accreditation standards and our academic membership organization regulations and my own Indiana University rules, not to mention faculty policies, because as a bunch of lawyers, we love to codify everything. So I do spend a lot of my time thinking about compliance and thinking about ethics, which, as a number of folks on this panel have emphasized, encouraging the right thing rather than what is simply required. So when I'm not administrating, my research and writing, at least over the last few years, has centered on insider trading regulation, and even more particularly, the dividing line between illegal tipping in violation of the federal securities laws or unlawful selective disclosure in violation of the federal securities laws on one hand, and the legal dissemination of issuer-specific information by corporate insiders on the other. And so these issues have compliance components, huge compliance components, that are critical to those who advise financial institutions and their employees, because securities analysts, securities brokers are all too often the recipients of illegal tips or unlawful selective disclosures. And so it's often compliance officials that is going to have to help the brokers and the analysts navigate between information that has been transmitted unlawfully and information that has been uncovered through diligent and legitimate research. So I thought I'd take the next 15 or so minutes here to share some of my thoughts to maybe assist with that task, or at least help folks here see their way through this sometimes very murky terrain. And I must say I'm particularly honored to be here presenting these thoughts in front of our keynote speaker, Judge Rakoff, who has authored a host of decisions very important to the law of insider trading, including the Ninth Circuit's decision in Salmon versus United States that the U.S. Supreme Court affirmed unanimously just under 3 months ago. So whenever I talk about insider trading, even to a group of compliance officials, students, even law professors who are well familiar with the law of insider trading, I always begin with the doctrine, because when we think about sharing material information or tipping information, it's always so easy to start with the personal benefit test, which really comes in at the middle, and we sometimes lose sight of why we're even talking about that. So I'm going to start with the very, very first principles and do so hopefully with lightning speed here. So insider trading is illegal, at least under U.S. federal securities law, insofar as it constitutes fraud under Section 10B of the Exchange Act and Rule 10b-5. And in the insider trading context, at least, a fraud occurs when a person remains silent about material facts in the face of a duty to disclose. And so where do we get that? We don't get that in the face of a duty to disclose from anything particularly Congress said other than the general anti-fraud statute. It was the Supreme Court in 1980 in a case, Chiarella versus United States, that ruled that a person who trades on material non-public information has a duty to disclose only if he or she stands in a fiduciary-like relationship to the shareholders on the other side of the transaction. And that's known as the classical theory of insider trading. 17 years later, in 1997, the Supreme Court, in a case called United States versus O'Hagan, which involved a lawyer who traded on a client's information, the Supreme Court ruled that one violates the federal securities laws from trading on the basis of information if he or she owes a fiduciary-like duty to the source of the information. So not the shareholder of the company that issued the security, but the source of the information, like a law firm or like a client. So that was the misappropriation theory of insider trading. So at first blush, trading by tippies, and here when we're talking about financial institutions, that's often securities analysts and broker-dealers, trading by tippies surely doesn't seem to fit within either the classical theory or the misappropriation theory, because typically tippies are strangers to the shareholders of the issuer, and they're also typically strangers to the source of the information. So it was the 1983 case of Dirks versus the SEC, a Supreme Court case, where Justice Powell, writing for the majority of the Supreme Court, created the fiduciary fiction that tippies owe disclosure duties to shareholders when the insider who shared that information did so improperly. And that idea that you can somehow fiduciaryize, I guess if that's a verb, the recipient of information also carried over to the misappropriation theory of insider trading, such that if a lawyer misappropriates information and then passes that on to someone else improperly, that someone else then inherits a disclosure duty to the source of the information, the law firm or the client. And so that's the paradigm here. That's the fiction that's at stake in insider trading cases. And the Supreme Court in this Dirks case from 1983 gave 3 examples of the type of improper dissemination of information that would work to fiduciaryize the recipient of that information. All 3 of these examples turn on whether the insider or the agent in the misappropriation context anticipated a personal benefit from sharing that information. And so this is often where the law starts. Did the insider, did the agent share the information for a personal benefit? But that's how we got to the personal benefit test. And what the Supreme Court said in the Dirks case is they gave 3 examples, or Justice Powell gave 3 examples of personal benefits. One is when an insider acts for pecuniary gain, and there a quid pro quo is the seminal example. Also, Justice Powell said if the insider acts for a reputational benefit that could translate into future earnings. And then the third example was if the insider gifts the information to a trading friend or relative. And so that's where we were in 1983, and then we have the misappropriation context for tipping as well. Well, for the next 3 decades or so, courts interpreted this personal benefit test fairly broadly, which means that they construed what it takes to constitute a personal benefit to mean any type of quid pro quo, any type of gift, any type of reputational benefit. And this worked. The SEC brought lots of cases. The U.S. Attorney brought lots of cases. In 2014, the Second Circuit put up somewhat of a roadblock in a case called United States versus Newmen. And that case has particular significance as we talk about compliance cultures in financial institutions, because that was a tipping case involving tips that came out of 2 publicly traded companies, Dell and NVIDIA, by the corporate insiders in those companies, down 2 separate streams of tipping to portfolio managers at mutual funds, or hedge funds, actually. And the Second Circuit then, for just about the first time, put a different test than the one that the Supreme Court set out in Dirks for illegal tipping, at least in the context of friendships. And what the Second Circuit said is that even if the government proves that a tipper and tippee are friends, disclosures are not illegal, said the Second Circuit, absent proof of a meaningfully close personal relationship that generates an exchange that is objective, consequential, and represents at least a potential of pecuniary gain or similarly valuable nature. So using that standard, then, the Second Circuit reversed the conviction of the hedge fund portfolio managers, claiming that there wasn't a particularly close friendship between the insiders at Dell and NVIDIA and their first generation of tippers, and that there was certainly no tangible benefit that came from the disclosure of that information. So the Second Circuit set an incredibly high bar. That decision prompted the defendant in the Salmon case to appeal his conviction. Now, unlike the very convoluted tipping chains at Dell and NVIDIA, the facts before the Ninth Circuit were relatively simple, and Judge Rakoff here sat by designation in the Ninth Circuit and actually wrote the Salmon decision, which affirmed the jury's verdict. The tipping chain there was very simple. It was an investment banker who worked at Citigroup who had confidential merger and acquisition information. He was badgered, if that's a technical legal term, by his brother, his older brother, who wanted the confidential information. The investment banking brother was eventually wore down by the pleas of his older brother and shared that information. And then the older brother not only traded on it, but tipped a good friend who later became a brother-in-law to the family. And so the case that was before the Ninth Circuit, and the argument was, well, it was the brother-in-law saying, I want the Newmen standard applied to me. The two brothers that exchanged the information did not do so for a tangible benefit. They were certainly meaningfully close, but they did not, the investment banker brother did not give the information for a tangible benefit. And so Judge Rakoff correctly read the Dirks case, said gifts of information to a trading friend or relative was one of the three examples that Justice Powell set forth. And this is a really easy case. And that to the extent that Newmen somehow said that gratuitous tipping a loved one needs a tangible benefit, the Ninth Circuit begged to disagree. When the Supreme Court issued its opinion this December, so just over 3 months ago, it was a unanimous decision written by Justice Alito. It affirmed Justice Rakoff's Ninth Circuit opinion, and the Supreme Court basically said, we meant what we said in Dirks when we said that gifts to trading friends or relatives constitute a personal benefit. That kind of begins and ends the story. So a very short opinion by the Supreme Court there. So what I'd like to do, though, is in 5 minutes or so remaining here, is to put forth a counterfactual. You know, what if the Supreme Court had before it not the easy facts of Salmon involving the investment banker who did everything but tie a bow around the gift to his brother, but what if it had the facts of Newmen? The analysts and the trading that go down two streams there. And as long as we're hypothesizing, what if the initial tippers in Newmen hadn't been friends or even friendly acquaintances? What if they were simply securities analysts who happened to get lucky and get on the phone with the insiders at Dell or an insider at NVIDIA? And last counterfactual, what if the insiders at Dell and NVIDIA were intentionally leaking the earnings-related information out of some misguided sense that it was benefiting their employers. If Dirks was our entire universe of Supreme Court precedent here, and if Congress and the SEC had never spoken on the issue, then we might well conclude that the insiders were free to tip and the analysts were free to trade, which is exactly what the Second Circuit concluded in the Newmen case. But were I arguing this case before the Supreme Court, I would emphasize the need to look beyond Dirks at 4 very important post-Dirks developments, so since 1983. And so these 4 developments, I'll tick them off very quickly and then just say a few words about each. So the 4 developments that I think, if the Supreme Court had this counterfactual before it, and indeed the Second Circuit, which did have a somewhat less convoluted version of my facts before it, could have considered is, first of all, the misappropriation theory of insider trading, that is, Justice Ruth Bader Ginsburg's majority opinion in the United States versus O'Hagan case. Secondly, what Congress has done since 1983 in the area of insider trading. The third is Regulation FD, which is when the Securities and Exchange Commission talks about selectively disclosing information in the vehicle of an SEC rule. And finally, state fiduciary law. So the misappropriation theory. Why is that relevant here to the counterfactual I set up? In United States versus O'Hagan, Justice Ginsburg emphasized that the liability that's involved with the fraud is when a fiduciary secretly breaches a duty of loyalty by sharing information to facilitate a tippee's securities trading. Whether or not the tippee is seeking a personal benefit, that is, the crux of the misappropriation theory is there's a disloyal agent that is keeping secret about their disloyalty there. And whereas personal benefit and self-dealing is the quintessential example of a breach of the duty of loyalty, it's not the only instance of a breach of the duty of loyalty. An insider who maliciously gives away corporate information would be breaching a duty of loyalty, even though that insider might not necessarily be self-dealing in that information. And what O'Hagan says is it's the secret breach of the duty of loyalty in connection with the purchase or sale of securities that constitutes the Rule 10b-5 violation. Second, Congress has certainly acted since 1983. In the year later, in the Insider Trading Sanctions Act in 1984. In 1988, Congress passed legislation, and then most recently in 2012 with the Stop Trading on Stop Trading on Congressional Knowledge Act, the so-called STOCK Act. You gotta love the acronym there. And so I argue in a recent article that Congress effectively ratified this fraud-based insider trading tipping prohibition. If I had more time, I'd elaborate. But what I really want to center the remaining part of my remarks on is Regulation FD. Regulation FD, adopted by the Securities and Exchange Commission in 2000, effectively prohibits the selective disclosure of material non-public information by corporate insiders to securities analysts and their privileged clients and other professional investors. Now, the Second Circuit in Newmen articulated its heightened test for tippee liability to facilitate efforts by analysts to gather and use selective disclosures in their securities trading. The Second Circuit was very clear and in fact went back to 1983 and Justice Powell's policy reasons for putting forth the personal benefit test in the first place. The Second Circuit, however, never once acknowledged in their entire Newmen opinion that the leaking activity at Dell and NVIDIA was done in flagrant violation of Regulation FD. Never once was Regulation FD mentioned in the Newmen opinion. Never once did the Second Circuit observe that the tipping activity, while not illegal under Rule 10b-5 because of the Dirks case, was nonetheless unlawful under Regulation FD. And here's where state fiduciary law then ends my discussion. So insider trading law is about federal law, and in fact, in deciding whether or not insiders breach fiduciary duties or agents breach fiduciary duties, we look to an enormous body of what is developed as federal common law. It was also Judge Rakoff who reminds us all that state fiduciary law gives federal courts a guide. It doesn't superimpose state law onto federal courts, but it is an important resource. And since 1983 and the Supreme Court's decision in the Dirks case, state fiduciary law, and most particularly the law of Delaware, which sets corporate law for so many of the publicly traded companies, Delaware law now makes clear that breach the duty of loyalty or breaches of the duty of loyalty include not only self-dealing, but also other actions evidencing a failure to act in good faith. So for those corporation students out there or counsel, that's the Disney case, the Stone versus Ritter case. Importantly, the failure to act in good faith includes the intentional violations of applicable positive law and causing a securities issuer to violate Regulation FD is a failure to act consistently with applicable positive law. So returning to the compliance themes I started with and I articulated at the outset, legitimate research by securities analysts should not ever be deemed to include taking advantage of information that was disclosed in violation of Regulation FD. And if we look at the 4 post-Dirks developments that I've just articulated, there's actually a legal theory that would say an insider who intentionally and repeatedly causes his or her company to violate Regulation FD is acting disloyally. And if they keep secret about it in connection with securities trading, they, at least theoretically, have violated Rule 10b-5, which means that the analysts and the broker-dealers who knowingly trade on violations of Regulation FD not only risk bringing into disrepute their trades because of some ethics and compliance rules at their brokerage firm, but they actually risk at least an argument that they are engaging in illegal insider trading as well. And so I'll stop there. Thank you very much.
Thank you very much, Donna. So we've had our 3 panels talk about resilience and nonlinear events and the role of compliance, cybersecurity, regulation, and compliance, and insider trading in Reg FD. I'd like to first turn to Judge Rakoff if he has any comments or questions for the panel, and certainly it's a great segue after talking about insider trading. Get the microphone down here.
Well, I am in total agreement and found very interesting what Professor Naki just said. All of the difficulties with insider trading now ultimately because there's no statute that criminalizes or makes a violation of any kind insider trading per se. So both the SEC and the U.S. Attorney's Office have had to shoehorn it into fraud under 10b-5 and in the criminal context also under mail fraud and wire fraud. And that to show that it's fraud because insider trading is simply done silently, so there's no express misrepresentations. You have to find some duty to speak, and that leads to all these complications. In Europe, though they were very late to come to the problem of insider trading, the SEC identified this problem originally in 1961 in a case called Katie Roberts. It wasn't until 2003 that the EU got to consider this. They promulgated a directive which is now binding on all members of the EU, which may or may not include Great Britain, that says, in effect, if you are in knowing possession of material confidential information, you can't trade on it, you can't tell it to anyone else, you can't encourage anyone else to trade on it, you can't do anything with it until it becomes public. And the theory of that statute is that the market demands equal access to information. Not equal information. Some person like an analyst can go out and develop a lot more information about a particular security than you and I would. And they're free to trade on that as long as it's public information. But it's unfair. It's a form of cheating, if you will, to trade on stolen information. And my own belief is we'd be much better off with a simple statute like that than with the convoluted case law that we now have. It makes it, the present situation in the United States makes it very hard for analysts. I thought that point was right on target. Because this is something of a shifting target. There are occasions, for example, when a company wants to leak otherwise confidential information in advance to prime the market for a lender takeover, for example, or things like that. So there are all sorts of difficult issues, none of which would exist with the kind of simple statutes they have in Europe. The second thought, I'm sorry that John Walsh had to leave. I'm a little skeptical about analogies from, if you will, the world of biology and the world of science to the world of finance. This is, I'm sure, unfair, especially in this absence, but I'm reminded of social Darwinism. Because Darwin showed that species developed through the survival of the fittest. That was said to justify colonialism and a lot of other bad things through a too facile analogy. So I thought he made a lot of excellent points about the complexity of modern organizations, but I'm not sure that the resilience of bacteria is necessarily the same as the resilience of traders and brokers and so forth. And the last point I wanted to make was that I hope our audience recognizes that everyone in this fantastic panel has made very good points, but they're not all consistent by any means. And the fact that everyone is being so nice and polite is I'm sure that there are considerable differences. And I am reminded of a very old joke that I first heard when I was 15 years old. So the two congregants come to the rabbi, and they are having a huge dispute, and the first guy says, it's all his fault, Rabbi, and here's what happened, and isn't it true that I'm right? And the rabbi says, yes, you're right. And then the other guy says, it's not that way at all. And he tells a very different story. He says, Rabbi, now that you've heard the full story, am I not right? And the rabbi says, yes, you're right. And then the two congregants say to the rabbi, but Rabbi, you just said we're both right, and our positions are totally inconsistent. And the rabbi says, yes, you're right.
So we'd like to have one question from the audience. That's really all the time we have. So if there is somebody. Maybe we're, okay, go ahead.
How do you measure success time for people in
That's actually a really good question, because one of the challenges of actually operating a compliance program, you're dealing with stakeholders, not just regulatory stakeholders, but stakeholders in the boardroom, is reporting. What do you measure? And what people tend to do, frankly, in my humble opinion, is count stuff that really doesn't tell you much. So it's like, this is how many people we trained. That's wonderful. This is how many escalations we had in our hotline. Well, that's also wonderful. And this is, and we haven't had anything go wrong. Well, that's also great, but that could be simply because people are doing their jobs and doing wonderfully, and it doesn't necessarily correlate with how great your program is. So it really is a difficult thing to do. So what ends up happening is it's actually hard to measure. It'll be easy to have a conversation about it if something blows up, and then people start pulling strings, and all of a sudden, there's a saying that success has many fathers, but failure is an orphan. All of a sudden, everybody runs off, and then you're left holding the bag. But I guess at the end of the day, the best you can do in terms of crafting a program is to obviously you will try to find out what types of issues may be coming up, and then keep track of those and maybe learn some lessons from them. You create a system of policies and procedures based upon standards and industry practice, and based upon what happens in terms of what the legal requirements are. And then it's like a living organism. So the way I describe the way a compliance program works is it's kind of like this continuous cycle of evolution. So you start with identifying the standards that apply to your business, and that's clearly available in the law, clearly available in regulation, industry practice. You take those standards, and again, management is the accountable party, so you're helping management figure out those standards. The next step is communicating them. How do you communicate them? Well, you do policies, you do training, you do memos or whatever. You tell the people in management that need to do the execution how to do it. So now you've identified them, you've trained them on or communicated them. Then now that they're doing it, the next step is, well, let me give management some feedback as to whether they're successfully doing it. So then you have things like surveillance, testing, monitoring, that kind of thing. And then what happens from there is either and this never happens, because there's always breakage, you'll get some feedback in terms of, to management about what things may be going off the rails, or slightly, hopefully. Then what happens is you have to deal with correcting the problem. You may have to go think about engaging with your regulators, responsible firms, do that. But the other thing that happens is that you learn a lesson from this. You learn a lesson in terms of what you learn from the breakdown. And then you can adjust it and maybe look at that, maybe think about some trends, mega trends, and say, look, this is how we should think about it based upon this new information. And then it's just sort of go back around the circle again. Now you're creating a standard, you're amending the standard. So it's this kind of organism that sort of consistently learns, consistently takes advantage of whatever is on the facts on the ground are. And to the extent you have a process like that, where you have sort of reasonable engagement with senior leadership, where you engage your board and they're aware of all this stuff, that's probably as good as it gets, frankly. So
very good. I to turn it over to Dean Harold Krent, who will give closing remarks, and then we'll head for the wine and beer.
Given the time, our closing remarks are a special thank you to the Clearing House Triple Foundation for creating a forum. They have judges, regulators, practitioners, academics mixed together in this very, as you said, polycentric issue of creating a compliance culture. So maybe there's been an incremental step towards more understanding today, and maybe there'll be even more outside. So please join us for the second.